Different European countries have treated processing of employee data with some nuance, and this nuance can be seen in countries like Germany. Hello and welcome back to Privacy Professional Training. My name is Fumi Owolabi. The purpose of my channel is to help individuals taking privacy certifications that I have personally taken. So today we're going to be continuing our series on the CIPPE exam, which is offered by the International Association of Privacy Professional. I will explain what the acronym is. It stands for Certified Information Privacy Professional of Europe. And just a bit of background, I don't think I've talked about this in other domains, but the exam itself is 90 questions. It's 2.5 hours. I have a whole video on my channel about how I passed this particular test a couple years ago, so you can check that out. Today, we're only going to be looking at domain 5. So one of the things I wanted to talk about a lot, which I think is incredibly pivotal and actually is something that you'll encounter in other privacy certifications too, is employee monitoring, employee processing of personal data. So I want to preface this by saying that how processing of employee data is conducted geography to geography is going to vary a lot. And as you continue your studies for this particular cert, you'll see that even within the context of processing of employee data, different European countries have treated processing of employee data with some nuance. And this nuance can be seen in countries like Germany, the Netherlands, and France. So take special care. Now, for this domain, we're just talking about employee processing of data generally, but if you work in one of these countries, it is going to be incredibly important to understand that there is nuance in certain geographies on how employee processing is going to be conducted. Now, let's talk about some of the other themes that we've seen in other domains. We know about certain assessments and documentation from a privacy perspective that companies must have. Now, I'm backtracking a little bit so that we can talk about employee processing of personal data going forward. The first document I want to talk about is called the RoPA, the Record of Processing Activity. This is a document required under the GDPR statute that requires organizations to identify their processing activities and other different factors within this document. So after talking about the RoPA, let's get into processing of employee data based on different factors that we've already identified in other domains. The first one is, on what legal basis can a specific activity associated with employees occur? Are we going to rely on legal obligation to process this personal data? Are we going to rely on legitimate interests for the business? Are we going to rely on legal obligation for a specific processing activity? And that was why I'd gone back and talked about the record of processing activity, because it's going to be incredibly important to document each activity associated with employee personal data. If an employee, for example, is going to log into an application that a business provides in order for that employee to do their job, the legal basis generally is going to be something called legitimate interest. And having that activity documented on your RoPA is going to be incredibly valuable. If there's going to be a particular monitoring activity that is going to be conducted on employees, say for example, the installation of CCTV surveillance or the keystroke logging of an employee as they work on their computer, businesses need to be thinking very deeply, or you'll need to be thinking very deeply about what legal basis might apply in that scenario if you encounter that type of question. So thinking about how employee processing is done in the workplace, what is permissible and what is not permissible, on what legal basis, and whether or not there is adequate enough notice that is being presented to employees for this processing activity. So you're not going to be looking at employee processing on its own. You're going to be thinking about other themes that you've encountered during your studies that influence any type of processing activity, including that nuance that consent is generally not relied on for certain processing activities. So one of the processing activities that I like to give a great example of where consent is generally used and obtained by organizations for employee processing pertains to obtaining photographs for a company-sponsored event. If a company has an employee-sponsored event and they want to take photographs. Let's say, for example, they've hired a photographer to assist in that. That is not an activity that is required for the company to conduct in order for the employee to do their job. It's something that is outside of their ordinary job duties. And as such, consent can be relied upon to obtain a photo release form from an employee in order to have their photos be posted on the social media platforms. In that instance, a business may rely on consent. So understanding the nuance for processing activity is going to be valuable during your studies. Next thing I want to talk about for today's video is I want to talk about marketing. Marketing is it's a well-discussed activity in the European Union because there are certain workflows that need to be met in order to obtain consent or to rely on an alternate legal basis in order to conduct certain marketing activities. So marketing can be conducted in lots of different ways. We've got telephone marketing, we have email marketing, we have in-person marketing. There's lots of different types of marketing activity, and there's lots of different sophisticated ways that businesses might want to process certain pieces of identifying information. Now, we're going back to some of the recurring themes. This is a specific activity. Some of the overarching themes we've discussed in other domains like domain 1 and domain 2, but consent is utilized a lot for marketing activities, but understanding what constitutes consent is going to be very vital for a specific marketing activity, in addition to the specific personal data identifiers that are collected for marketing activity. So in order to conceptualize this, I'm going to give an example. If you see a contact form that belongs to an organization and it's currently on the website, if the contact form collects name, email address, and country of residence, one of the overarching privacy themes that needs to be considered is this the minimally required personal data in order to conduct this particular marketing activity? So if the form itself is collecting more than is required, then we are looking at a potential infraction of the concept of data minimization. The second thing is the language that constitutes consent. Is it informed? Is it freely given? Is it unambiguous? Is it just as easy to withdraw as it was to give? Are these factors being met for consent? And does the language articulate this sufficiently? We don't want to be conducting an activity where consumers or prospective customers for these marketing activities are not clear on what it is exactly that they're consenting to. So the language needs to be placed in a specific type of way. In addition to that, there is the concept of opt-in. Now, understanding the distinction between opt-in and opt-out is going to be pivotal in the discussion for domain 5, because what constitutes opt-in is very different for opt-out, and the responsibilities that a data controller, right? We've mentioned this term before. A data controller is an entity that determines the means and purpose of processing. So is the group that is conducting this marketing activity, are they acting in a data controller capacity or are they acting in a data processor capacity? Understanding the responsibilities with these two is also going to influence how a marketing activity can be conducted. And then in addition to that, one of the other themes that is going to be evident, not just explicitly in domain 5, but in other domains, is not using the data for a secondary purpose. If we're going to be obtaining personal data for a specific purpose, in this instance, email marketing, it can only be used for email marketing unless we get consent for the second purpose. These are two themes that you're going to see in domain 5. One, understanding the nuances around employees. You're going to see themes that have been talked about in other domains that are influenced by how processing of employee data can be conducted, and understanding the different processing activities that allow an organization to process employee data is going to be pivotal. In addition to the fact that generally with employees, we might be able to see certain special categories of personal data. For marketing efforts, understanding the nuance associated with opting in and opting out, obtaining actual consent, and storing the consent that is obtained in a specific platform is also going to be valuable. What does the GDPR statute dictate when it comes to email marketing, and how is the interpretation of consent conceptualized under the GDPR for a specific activity that a business wants to do? So you need to be thinking about different marketing activities that a business can conduct, and also what legal basis they may be able to rely upon in order to conduct that activity, and what the consent language is that's appropriate for that activity, and whether or not there's adequate notice that covers the marketing activity that's going to be conducted. So I really hope you enjoyed this breakdown of Domain 5 for the CIPPE exam. If you like this type of content and you are taking the CIPPE exam and you would like additional questions that you can complete in order to test the knowledge that you have during your studies, I have a book available on Amazon for purchase and you can see the link below. I will see you in another video.